I'm Jim Rossi, the Associate Dean for Research here at the Law School, and it's an honor to welcome you to the 31st Annual Martin Luther King Jr. Lecture at Vanderbilt Law School. Martin Luther King Jr. once said, "Our lives begin to end the day we become silent about things that matter." And it's in the spirit of this insight that we have welcomed distinguished jurists, legal scholars, and practitioners to the law school to engage our community in discussing the most difficult legal topics related to race and society. Before introducing today's speaker, I'd like to thank the law school's dean's office. Dean Chris Guthrie has provided financial support for this lecture. Bernadette Paschal Graffried and Kyra Cruz Street have provided the logistical expertise to make this event possible. And I'd also like to thank the Black Law Students Association for its support in promoting this event among its membership and more broadly within the law school. It's an honor to introduce today's MLK lecturer. Jamal Greene is the Dwight Professor of Law at Columbia Law School, where he teaches courses on constitutional law, comparative constitutionalism, the First Amendment, citizenship, federal courts, and the law of democracy. Following his graduation from Yale Law School, he served as a law clerk to the Honorable Guido Calabresi for the U.S. Court of Appeals for the Second Circuit, and then he clerked for Justice John Paul Stevens on the U.S. Supreme Court. Professor Greene is the author of more than 30 law review articles and is a frequent media commentator on the Supreme Court and on constitutional law. His scholarship focuses on the structure of legal and constitutional argument and is brimming with doctrinal, historical, and theoretical insights of relevance to public law and discussions about race and rights. To give one example, he's written the canonical article on the anti-canon. The article is called The Anti-Canon, published in Harvard Law Review in 2011. It's a fascinating assessment of how and why decisions such as Dred Scott versus Sanford and Plessy versus Ferguson have become a part of that set of legal cases that all legitimate judicial decisions must, at some level, refute or engage critically. I could give many more examples of the contributions he's made, which are quite important and significant, but I think you'd much rather hear from him. That's why we brought him here. And today we're fortunate to have him here to discuss his new book project in a lecture entitled The Rights Epidemic: How the Addiction to Absolute Justice is Dividing America and What We Can Do About It. Please join me in welcoming Professor Jamal Greene to the lecture. Thank you.
Thank you. Thank you for that generous introduction, and good afternoon to all of you, to faculty, students, affiliates, and others. I want to talk about rights adjudication in a constitutional democracy. This is obviously something we talk about a lot in law, especially in public law, something we talk about a lot in politics and in political theory. And of course, the importance of equal rights for all is a dominant theme of the legacy of Dr. King. I want to focus today on the phrase equal rights. It rolls off the tongue, to be sure, but its kind of mellifluous tone, equal rights, masks a tension between the words equal and rights. I think most of the conversation around rights adjudication misses something important in that tension, and therefore something important about the role of judges in a pluralistic democracy. To make the point more clear, I'll start with an example. The example is well known to German constitutional lawyers. It's well known to students of what in other constitutional systems is called proportionality analysis. It may be less well known to many of you. In the early 1980s, the German Constitutional Court heard a case about feeding pigeons. A woman who liked to feed pigeons in a public square and was facing a municipal ordinance forbidding the feeding of pigeons, brought a constitutional case under the German Constitution, which is known as the Basic Law. At the time, it was the West German Constitution, but we'll just call it the German Constitution for now. She said that not allowing her to feed pigeons in a public square amounted to an infringement on what the Basic Law, again, the German Constitution, calls the free development of her personality. That's something akin to a kind of liberty or autonomy right, as we would understand it in the United States. How should a court think about that kind of claim and that kind of case? To many students of American legal education, how to think about this kind of case will seem fairly obvious. The question in the case, from a US constitutional law perspective, is, does the Constitution protect a right to feed pigeons? That framing is almost axiomatic within American constitutional discourse. This, in turn, is fundamentally a question of constitutional interpretation. The way to answer questions about constitutional interpretation is to explore whether the Constitution's language or structure or history or precedent has been read to protect this particular kind of right. So we look to text, to structure, to history, to precedent. And if the Constitution protects the right, then the government should probably lose the case, unless it has extraordinarily good reasons for banning the feeding of pigeons. And if the Constitution doesn't protect the right, if it shouldn't be properly interpreted to protect the right, then the woman should probably win the government should probably win its case, unless the reasons for feeding pigeons are totally arbitrary. Now, mind you, banning the feeding of pigeons. Mind you, viewing the question as primarily interpretive is not just the lens that people on the right, or people who are originalists, or people who are textualists would use. It's basically the lens that all US-trained constitutional lawyers would use in this sort of case. It might be that originalists are more likely to focus on text or history, and that non-originalists are more likely to focus on precedent or consequences. But under either lens, the question is fundamentally an interpretive question. And the answer to that question, under either lens, is clear. Text, history, structure, precedent of the US Constitution and US constitutional law do not protect a right to feed pigeons in a public square. The claim would therefore be rejected, again, unless the government's reasons are totally arbitrary, which they aren't. They wouldn't be. Now, the German Constitutional Court, which heard this case in the early 1980s, analyzed the woman's claim in a different way. It held that there is a right to feed pigeons in a public square. Indeed, it held that there is a right to feed pigeons in a public square without very much analysis. The question wasn't whether feeding pigeons was somehow listed somewhere in the German Basic Law, or whether the intentions of the framers of the Basic Law would have thought that feeding pigeons was something that was protected or fundamental. The question wasn't about fundamentality really at all, at least not as to all Germans. It was enough that the freedom to feed pigeons in a public square was important to this person. It was an activity that gave meaning and value to her life. It was a claim that was, for that reason, worthy of respect. Now, of course, that could be true of a great many activities. We're all very different people. We all have very different commitments and values. But the fact that the set of actions that could implicate important rights, in this case feeding pigeons, was potentially a broad category, was not a reason to reject the claim. What it meant instead was that the case had to turn, again, not on whether as an interpretive matter there's a right to feed pigeons, but it had to turn on what the government's obligations are in virtue of that right. If feeding pigeons is really important to some people, then regulating that activity must have some substantial relationship between means and ends. It must not impair the right to feed pigeons any more than it has to. And any regulation shouldn't be disproportionate, or at least grossly disproportionate, to the nature of the problem. Some of you will recognize these considerations as sitting at the core of, again, what is known internationally as proportionality analysis. Some of you will recognize some features of it in the tiers of scrutiny analysis that's used under US constitutional law. In the pigeon feeding case, the city was able to satisfy these considerations, in fact, fairly easily, on the basis of the risk of property damage, the spread of disease, and other considerations from feral pigeons gathering in public squares. So no matter which way you analyze the case, whether you analyze it under the US frame or analyze it under the German frame, the pigeon feeder loses. So why does it matter? And is one of those frames any better than the other? I want to suggest that it does matter, and that the German frame, what I'll call the German frame just for ease of exposition, the German frame, the one closer to proportionality analysis and the one further away from the US approach, is a much better fit for modern constitutional democracy. This is so because modern constitutional democracies face what I will call a rights epidemic. Now, referring to rights in those terms, in terms of an epidemic, may sound bracing at first. Epidemics are usually bad. We think of them as a bad thing. And so using that terminology to talk about rights seems to pathologize them, to liken them to a disease or a contagion. That's not usually how we like to think about rights. We usually think that those are, again, a good thing. And yet, I find the frame useful for a number of reasons. I'll give you three. The first reason is that there's no reason necessarily to think of the advancement of rights per se as a positive social good. As both critical theorists and social conservatives have pointed out from very different perspectives, the proliferation of rights has the potential to be quite destructive of community. Free speech rights or gun rights provide ready examples. And as Dr. King was all too aware, the case for segregated schools and segregated buses and segregated lunch counters was persistently framed in terms of rights. Second, the epidemic frame, using that terminology, serves to emphasize the important point that rights are not something that a community simply recognizes and then honors without reflection and care. At least they're not something that a community should simply honor and recognize without reflection and care. Rights often, and indeed constantly, come into conflict with other rights or with other public priorities. And so it's not enough just to recognize them and then move on. One also has to manage them. Institutions with the power to enforce rights need not just develop tools of identification, but also tools of administration. Rights represent enormous political and bureaucratic challenges. Third reason why I think the epidemiological framing is useful in this context is that rights are part of the human condition. Even as their enforcement imposes and can impose massive externalities on other people, rights are intensely personal. Rights do not come into conflict because some people are wrong about the rights that they have and other people are right about the rights that they have. Rights come into conflict because we are all different from each other, and yet we have to live together. Rights conflict is, in that sense, a byproduct of pluralism. The more different kinds of people you have living together, the more daunting the management challenge that rights proliferation represents. And so let's return to the different ways of confronting the management challenge that I identified with, on the one hand, the US approach, more categorical, more absolutist, and on the other hand, the German approach, which again, I'm using as kind of ideal types. These are really kind of a spectrum. Recall that the US approach to rights conflict the first type, is to focus on whether the claimant has a right, I'll put in quotes, has a right as a matter of constitutional interpretation. That whether they have a right will be uncovered by text or history or structure or consequences or precedent. The German approach, the second type, instead focuses primarily on whether the government is justified in the way in which it limits that right. Again, our pigeon feeder, God bless her, loses on either approach. But I want to suggest that understanding rights as a management challenge helps us to see that how she loses matters. Consider first that under the US model, whether a claimant wins or loses depends almost entirely on whether the adjudicator characterizes the claim in rights terms. Characterizing the claim in rights terms has enormous consequences. Remember, rights enforcement can, indeed almost inherently is, socially disruptive. And so we can expect the adjudicator to be quite stingy in recognizing enforceable rights in the first place. We observe that stinginess in many aspects of US constitutional practice. And I'll mention a couple of conspicuous examples here. So first, US courts are highly dismissive of social and economic rights, many of which have substantial positive dimensions. One of the leading cases, many of you will have seen this case in your constitutional law class or if you took an education law class, the San Antonio Independent School District versus Rodriguez, 1974 case, in which the Supreme Court rejects a constitutional challenge to enormous disparities in funding between public schools in different neighborhoods in and around San Antonio, because local property tax receipts were a major source of revenue for school funding. The court said it was rejecting the claim. It was a 5-4 case. The court said it was rejecting the claim in part because accepting the claim of equal funding of schools would require courts to intervene in equalizing any number of other public services, such as police services and fire services and public hospitals. Of course, none of those claims were in front of the court at the time. What was in front of the court was a claim about funding of schools. But the court said, well, if we recognize that, we've got to recognize all these other things, and we can't do that. The court also rejected a claim of the right to education, which was brought on both equality and fundamental rights grounds, rejected a claim of the right to education on the ground that recognizing that kind of right would call into question why there is no right to food or right to shelter or right to clothing under the US Constitution. Those seem equally important and equally vital to the exercise of other rights, right? But the court said, well, we don't recognize those, so we can't recognize this. In other words, the court cast about for the appropriate category into which it might place the rights claim being advanced. And if the implications way downstream, the implications of recognizing that category seemed intolerable for some reason, then there must be no such right. The category just doesn't work. Second example of the stinginess of US courts in recognizing rights, so-called disparate impact discrimination, called indirect discrimination in many other jurisdictions around the world. Disparate impact discrimination is, as most of you will know, discrimination that is not specifically intended, as when a policy has a more severe impact on members of one sex or members of one racial group, let's say, than on others. Disparate impact discrimination is not recognized constitutionally in the United States, either in the case of race discrimination or sex discrimination or religious discrimination. I am not aware, by the way, and maybe some of you are, but I'm not aware, and I teach comparative constitutional law, not aware of any other court system in the world that categorically refuses to recognize disparate impact discrimination as a constitutional claim. In the leading race case involving a civil service exam administered to people who wanted to become DC police officers, the court said explicitly that recognizing disparate impact claims would call into question too many laws. It would call into question tax laws and welfare laws and criminal laws. In the leading case rejecting disparate impact religious discrimination claims, Justice Scalia wrote the majority opinion, and he memorably said that recognizing such claims would be, quote, courting anarchy. It would, and now I'm quoting Justice Scalia, it would, quote, open the prospect of constitutionally required religious exemptions from civic obligations of almost every conceivable kind, ranging from compulsory military service to the payment of taxes, to health and safety regulations such as manslaughter and child neglect laws, compulsory vaccination laws, drug laws, traffic laws, social welfare legislation such as minimum wage laws, child labor laws, animal cruelty laws, environmental protection laws, laws providing for equal opportunity for all the races. All of those laws, he suggested, might be invalidated if the courts recognized even a single disparate impact claim. Needless to say, none of those laws was before the court. The case was about members of an indigenous tribe who wanted to not be fired for smoking peyote as part of a religious ritual. It didn't involve the tax laws or the social welfare laws. Third example of stinginess by the US court. The recent case refusing to find partisan gerrymandering justiciable. In the gerrymanders at issue in the case, politicians admitted openly that their goal in drawing district lines was to reduce the number of seats won by the opposing political party. Again, just to think internationally, I'm aware of no country in the world, maybe there are some out there somewhere, but I'm not aware of them, in which drawing district lines to favor one's own political party is considered to be legally acceptable behavior. It happens in many places, but it's illegal. And yet the court refused to see any enforceable problem with this practice. Not because it found the practice consistent with democracy. In fact, Chief Justice Roberts said the opposite of that. He said that it seems to be quite anti-democratic. But because the court could not figure out how to devise a rule of which gerrymanders were acceptable and which gerrymanders were not acceptable. In each of these cases, claims that might have been compelling on their own terms, the students' equal education rights, the DC police officers' rights, or potential DC police officers' rights, the victim of a gerrymander, were ignored because the court was uncomfortable with the other kinds of claims that might fit into the same category. Importantly, the bounds of those categories were not set by whether it would be just or fair to recognize those claims. A right to food or a right against political gerrymanders is not unjust or inconsistent with justice. Rather, the claim was that because of text, history, structure, precedent, other judicial interpretive questions, or maybe the self-understood, self-recognized institutional limits of judges, these categories of claim were off limits in constitutional rights adjudication. This mode of reasoning separates out the question of justice from the question of conflict resolution. The hate speaker, whose claims are recognized, the gun toter, whose claims are recognized, the person who doesn't want to join a union or pay dues, their claims are recognized. The corporate electioneer in Citizens United, their claims are recognized. The commercial marketer, their claims are recognized, not because their claim is more just, but because they can fit their claims into the right kind of interpretive category, freedom of speech or gun rights. The suffering school child or the religious minority or the gerrymandering victim, they're out because they can't fit their claims into some established interpretive category. What is foregrounded is a dry interpretive question, not the actual stakes of the conflict in human terms, not the actual behavior of the government, not the interests the government is pursuing, not the burdens placed on those who are affected by the government's conduct. the US approach prevents rights and justice from engaging with each other. Why else might it matter which model of rights adjudication or rights management a jurisdiction pursues? The US model denies courts the resources for dealing with conflicts of rights. It is highly unusual, in fact, I can think of almost no examples, and I know a lot of constitutional cases, can think of almost no examples where a majority of the US Supreme Court even acknowledges the presence of multiple and competing rights within a single case. If rights are presumptively absolute, as they are on this model, then it's awkward to acknowledge the presence of rights conflict. One needs a way to work out that conflict, and US courts haven't devoted any real energy to doing so. This was, I believe, part of the reason the Supreme Court in Roe versus Wade pointedly held that a fetus does not have constitutional rights. In fact, Justice Blackmun, who wrote the majority opinion in Roe, says, if a fetus has constitutional rights, the case is an easy one. It must be the case that Texas and Georgia have to win in Roe versus Wade and Doe versus Bolton. As if there's no way for a rights claim to be recognized and nonetheless lose because of the presence of other rights. In fact, the first German abortion decision, there's two big ones that are roughly contemporaneous with Roe and Casey. The first one happens in 1975. The court had to rule on an abortion liberalization statute. So this case comes from a very different direction from Roe versus Wade, where the court is ruling on a prohibition on abortion. And the court strikes down the law, the liberalization law, on the ground that the government had not sufficiently satisfied its constitutional obligation to recognize both the value of fetal life and the autonomy interests of the pregnant woman. There's a whole lot one can say about the German abortion jurisprudence, but without diving too far into what is a very complex set of cases, the court's nudging has helped abortion politics in Germany towards considerably more political consensus than what one sees in the United States. Failing to recognize rights conflict forces the court into just the posture that one observes in Roe versus Wade, of a court feeling the need to declare, in the face of multiple and competing good faith assertions of right, that one side has a right and the other side does not have a right. That one side is a subject of constitutional concern and the other side is not a subject of constitutional concern. This is quite a momentous thing for a court to announce. But it fails to live up to the momentousness of that kind of judgment if the court is making the determination of who counts under the Constitution on the basis of dry recitations of history or precedent, rather than on the basis of the actual behavior and motives of the government and the scope and magnitude of the burdens that it is imposing on citizens. Which brings me to a third, and I think largely underappreciated, consequence of the US rights approach. It seems almost calculated to exacerbate political polarization. Rights conflict becomes an existential conflict in which one side will win the Constitution's favor and the other side will not. It forces litigants and their lawyers to align their opponents with extreme positions in order to show that the category their opponent fits into is an intolerable one. The Masterpiece Cake Shop case provides a ready example. Some of you, many of you, are likely familiar with this case in which a baker in Colorado refuses to bake an artisanal wedding cake for a same-sex wedding. The same-sex couple claimed that this violated the state's anti-discrimination laws, state of Colorado. The baker claimed that applying those laws in this particular context would violate his freedom of speech. Now, there's, again, a lot that one can say about this case. There's a lot going on in the case, but I want to focus for the moment on how it was argued in court and publicly presented in the media and in other public discourse. It's hard to see, but the two sides actually had, there's really three sides because it's the state and the couple and the baker. They actually had a fair amount in common if you dig deep into their legal arguments. All sides agreed that the state cannot compel someone to produce a work of art against that person's will. All sides agreed that the fact that an artist happens to operate a business that's supposed to be open to all people doesn't change that fact. It still means the state can't require someone to produce art against their will. All sides agreed that art can be edible and that this baker's cakes are indeed artistic. Both sides also agreed that the freedom of speech that protects an artist does not permit that artist to discriminate against customers on the basis of their sexual orientation under Colorado law. I'll say that again. Both sides agreed that freedom of speech that protects an artist does not permit the artist to discriminate against customers on the basis of the customer's sexual orientation under Colorado law. So what did they disagree about, one might ask? What they disagreed about was whether refusing to sell a cake for use in a same-sex wedding qualified as sexual orientation discrimination against customers or not. The baker said, I don't want my cake to be used in a same-sex wedding. I don't care who the customers are. The customers can be gay or straight, it doesn't matter. I don't want my cake to be used in this particular setting. The couple said, if we were not a same-sex couple and were asking for the same cake, you would give us the cake. So disagreement. In the grand scheme of things, kind of a narrow disagreement, a very broad agreement on a lot of really interesting propositions of constitutional law. A court that was focused on rights management rather than just rights recognition might want to highlight the broad agreement between the parties in order to produce a fair and just outcome in the case. Maybe, for example, the baker could hire a sous chef to bake the case over. What happened instead is that the knives came out. At oral argument, Justice Gorsuch asked the ACLU's lawyer whether the Colorado law would require a baker to sell a cake with a cross on it to a member of the Ku Klux Klan. Justice Alito asked the state's Solicitor General whether the law could force the baker to provide a cake honoring the anniversary of Kristallnacht, an important moment in the Nazi persecution of German Jews. Justice Breyer and Justice Kagan both compared Masterpiece Cake Shop to Ollie's Barbecue, the whites-only Alabama restaurant that challenged the public accommodations provisions of the 1964 Civil Rights Act. If you look at the briefs by the parties and the amicus briefs in the case, they are littered with slippery slope arguments that are designed to show the purportedly dystopian universe that the other side's position invites. One brief said that for the couple to win would violate the 13th Amendment's ban on involuntary servitude. One brief said that if the couple were to win, the government could disbar Christian lawyers or strip Christian doctors of their medical licenses. A brief said the win for the couple meant the government could force Jehovah's Witnesses to salute the flag, could force Virginia Baptists to pay to support mainstream Christian teaching. The couple's position was likened to the Spanish Inquisition, to forcing Christians to bow before Roman gods, to forcing Jews to submit to the golden statue of Nebuchadnezzar, compared to the beheading of Sir Thomas More. According to briefs on the other side, which were more tempered, I will say, a win for the baker would justify anti-miscegenation laws and school segregation laws. It would allow landlords to refuse to rent to interracial couples, would allow a racist baker to refuse to sell a happy birthday cake to African-American customers. A printer could refuse to sell a banner announcing a Muslim family's reunion. A tailor could refuse to sell a gay man a custom suit for a charity gala. A family portrait studio could enforce a no Mexicans policy. A banquet hall could refuse to host events for Jewish people. A hair salon could turn away a lesbian woman or refuse to help a teenage girl prepare for her quinceañera out of opposition to Mexican immigration. Again, none of those cases were before the court. Whether you think the baker or the couple should win in Masterpiece Cake Shop, the idea that a case with substantial agreement between the parties should be adjudicated based on hypotheticals about Nazis and segregationists paints those who disagree with us as our enemies. This is exactly what the existential rights frame of the US model encourages. And there's another point to be made about Masterpiece Cake Shop. The case was also about a conflict of constitutional rights. The rights of the baker on one side and the equality rights of the same-sex couple on the other. Those rights were in tension with each other. But notice that the constitutional form that the couple's rights took in Masterpiece Cake Shop was not a judicial recognition of constitutional rights, but a state law. Americans are accustomed to thinking of rights as something that judges recognize against the state, right? But there's no reason that this should always be so. Rights are also something that representative political institutions recognize. And indeed, I would suggest that this is the predominant way in which rights are recognized and enforced, through laws. Part of the reason that this can be hard to see is that viewing rights recognition as primarily an interpretive question judicializes the rights discourse. Judges, not politicians, judges are trained to examine text and constitutional history and constitutional structure and precedent. That's what you're all being trained to do here. Lawyers and judges become the high priests of constitutional rights. Other forms of political behavior are separate and apart from rights recognition. And so when it comes to rights, lawyers, judges are privileged, and the rest of us simply await their pronouncements about what rights we have. This posture has some unfortunate consequences. Perhaps most damaging, the reconciliation of competing rights claims is the sort of project we should want well-functioning legislatures and executives to engage in. Right? This kind of negotiation relies on the sensitive political judgments, the qualitative distinctions that we rightly think should be made in the first instance, not by judges, but by other, more accountable actors. When courts determine constitutional rights questions on the basis of criteria that political actors can actually access and form judgments about, government means and ends, burdens to individuals, costs, it encourages all of us to be part of the conversation about rights. It makes politicians have to think about the stakes on all sides of laws that implicate rights. I'm not an originalist, and so there's some irony here in my emphasizing what I'm going to say in a moment, which is that what I'm advocating here is in fact how the US Constitution's framers drew it up. The US Bill of Rights, which has become a symbol of US rights absolutism, is much better understood as being committed to reliance on, in that case, particularly local political and social institutions to identify and protect rights. Now, I could say much more about that if people are interested, but the key point is that the US approach is not some kind of inheritance from the framers. It's not in our DNA. It is, I believe, a highly contingent artifact of the 1960s and 1970s, in which an explosion of rights claims, an epidemic, if you will, of sexual freedom, women's rights, criminal justice, welfare rights, free speech, second-generation civil rights claims, all being recognized for the first time, asserted by influential lawyers and litigants for the first time, all in the same period. Chastened by its own historical experience with the so-called Lochner Era, when it was criticized for employing a balancing approach to rights, the court made a choice. The choice it made is the categorical approach that we have inherited to this day. But that approach simply cannot be sustained in a rights-saturated environment, in a context of, again, what I've called a rights epidemic. Last thing I'll say before getting to questions is what I'm saying here and the project in general is not utopian. It's quite the opposite. There is no ideal form of judicial review, just as there is no ideal form of government. Even the best forms are going to get a lot of things wrong. They're going to result in errors in judgment. They're going to result in unadministrable constitutional schemes, in social experiments that go bad. Part of the overarching point that I want to make is that judging is a human endeavor, and so we should design institutions that are well suited to respond to the flaws in human judgment, the flaws in human wisdom, the epistemic challenges in human problem solving. The US approach assumes too much about the ability of judges to make consequential and far-reaching claims about the rights that people have and the rights that they do not have. The alternative to that is not perfect adjudication. The alternative to that is highly imperfect adjudication that nonetheless recognizes its own imperfections and therefore insists on asking the right questions and forcing the political branches to ask the right questions about the state's actions. Why is it acting? On what assumptions? Are those assumptions correct? And do they justify the burden placed on those affected? Thank you.